All right, welcome back. Let's talk a little bit more about the actual tax deed itself. And this is all based on Florida law. Again, you guys have to know your law, or at least be able to reference it in some type of page to make sure that all this makes sense. So let's see, who issues the tax deed? Tax deed shall be signed, witnessed, and notarized. Nothing survives a tax deed except for municipal or county government liens of record. And the people that issue this thing are going to be the people that work in your county administrator offices. They're signed by somebody that's authorized to sign it. It's not a magic document, but it is a deed nonetheless. So now you own some property. That's good news. The grantee is entitled to immediate possession. We just talked about that a little bit, and my little way around it works 85% of the time, and it works good. Let's see. The owner of a tax deed shall be allowed immediate possession to the property. Consider how this differs from foreclosure, where a buyer at the sale must wait through a 10-day objection period and or must be required to obtain a writ of possession to secure the property. In my experience, some owners of property sold at tax deed auctions have refused to vacate their property after being asked. The statute makes it clear but offers no real relief should the occupant refuse to leave. Please see my section regarding county court versus circuit court evictions. I don't have a section in here, but I just tell you, they're different. Foreclosure investors, they got to go through a whole bunch of rigmarole. You got to wait 10 days. Anybody can object. If there's one objection, the judge has to hear a hearing. Now you have to decide whether you hire an attorney because you're not a party to the sale. Long story short. This one here for tax deeds, while it can appear to be a little more difficult because the statute doesn't give you a way other than suing for a writ of assistance, I like my way. I like what I do with the small claims court because I didn't know. It works good. And on top of that, the defendant didn't know. And you know what? If they find out and they learn the law better than I know it, which anybody does, hardly, almost, and they get an attorney, we got to go to circuit court. We'll go to circuit court. So no harm done. Okay, let's see what's going on next. The disbursement of the sale proceeds. Ooh, this is good. When a property is sold to a third party, the clerk shall immediately pay the certificate holder all sums due, including all principal, costs, fees, and interest. See that certificate holder, I'm telling you, man, tax deed investors and tax certificate investors are treated like kings and queens in this state. Notice that they don't have to make application for the money. They don't have to request it. They don't have to do anything. Once the money's clear, the clerk will send it all, everything that they're owed, to the tax certificate holder, to the person who made the tax deed application. So here's a little bit more. Should the sale result in excess funds, the winning bid exceeding the opening bid creates a surplus funds, excess funds, the clerk shall first pay governmental liens in full. Now, it doesn't even say, the law, that the governmental entities have to make a claim for the money. Some do, some don't. And to me, it all depends on whether their attorney wants to generate some hours. If there remains a balance after all those governmental entities have been paid, then that'll be held for those benefits, for the benefit of those with a recorded interest. Recorded interest. Very important that we understand what that means. I'm going to talk to you about it in just a second. Right where the line says first in time, first in right, we're going to get right there. I had my microphone down the street, sorry. Should any balance remain after the full payment of the municipal or county government liens, the excess funds shall be distributed in order of priority as described on the county title report. However, a claim must be filed with the county. Parties with claims must be proactive, or their funds may escheat to the state of Florida. Now, that escheatment time is different in every state in the union. Some states it's longer, some states it's way shorter. But let me first explain how we establish priority. So priority is simply this: first in time, first in right. I'm going to read on a comment. Priority is a concept that must be understood in order to profitably work any tax default. Whether you're working with tax certificates pre-sale or surplus funds post-sale, you'll need to completely understand priority. First in right, first in time is an easy concept to apply, but you'll need to understand it very deeply in order to structure deals properly. It's similar to poker in a way that poker takes 10 minutes to learn and a lifetime to master. And I'm partially through my lifetime. I still don't get it. So priority is just that, priority. If your recorded document is recorded first and their recorded document is recorded second, you have priority over them. Therefore, your claim must be paid in full first. And if anything is left over, those that are second in priority can receive it. Priority stems from the recording information on any document in question. The document with the lower recording book and page or instrument number has the highest priority because it was recorded first. Okay, I hope you all got that. Everything is based on the priority of recording. And if your item is recorded, be it a judgment, a lien, a claim of anything, claim of interest, it's going to show up on the title report. And the clerk is going to determine who's entitled to the surplus by reviewing the title report, because the title report will have books, page, and instrument numbers. And of course, the lower the book and page or the lower the instrument number, the higher your priority. You got that? Because they were recorded first. Now, notice I said the clerk, because in an administrative setting like Broward County tax deeds are, and you have to check the way it is in your county. In an administrative setting, the clerk is not a judge. They're appointed officials. And I talk about them a little bit later, but these clerks are taught how to read a title search, and they go just by the facts based on first in time, first in right. Okay, we'll get back to this a little bit later. Let's talk next about reimbursement required in a challenge to the validity of a tax deed. Now, I said somewhere previous in this training that I have only seen one tax deed get set aside in my entire career, and I've seen a lot of tax deeds. But if it does get set aside, remember how I told you that tax deed investors are cream of the crop when it comes to the Florida estimate of their value to the state? Well, here's another example. If you buy a tax deed and it's challenged in court for any reason other than payment, so in other words, if you pay for it, you're good. I'm sorry, if payment is made by the owner. If the owner made payment and it went to sale anyways, that was a mistake, you're just going to get your money back. But if you buy a tax deed and it's challenged in court for any reason other than that the homeowner made payment before the sale, the tax deed holder will be reimbursed all of their costs, interest, and potentially attorney's fees. Your tax deed will cloud the title until the dispute is resolved, and you either receive a full refund, including interest, or the tax sale is confirmed. So what this is saying essentially is that if it's challenged, even if somebody files a lawsuit, you hire an attorney, you're going to be able to get your attorney's fees back. You're going to have to ask for it because the statute doesn't look like it guarantees attorney's fees, but it says you could potentially. So that means you should ask the judge for it, because the fact is this is none of your fault. You didn't do anything wrong. So you're going to get all your interest, all your money back, 1.5% interest from the sale date, a whole bunch of good stuff, because they want that tax deed investor to be happy. All right, so we all know that tax deeds, you can't sell the property right away because you have uninsurable title. And the next chapter, we're going to talk about how to obtain clear title. And some of the ways I talk about, or at least one of the ways I'm going to expand on, is guarantees to surprise you.